A major victory for gay equality. An historic U.S. Supreme Court decision strikes down a federal law defining marriage as only between a man and a woman. But there's a major defeat for racial equality as another Supreme Court decision guts the 1965 Voting Rights Act, which protects minorities from abuse at the ballot box. You're watching Inside Story Americas from Washington. Hello, I'm Shihab Rattansi. This week, the U.S. Supreme Court handed down major rulings that will likely have a lasting impact on civil rights. On Wednesday, it ruled that the Defense of Marriage Act is unconstitutional. The law barred the federal government from recognizing same-sex marriage. Kimberly Halkett has more from the Supreme Court.
Two landmark rulings from the U.S. Supreme Court on same-sex marriage. The Defense of Marriage Act, a 1996 law recognizing marriages between only a man and a woman, being ruled unconstitutional in a 5-4 decision by the Supreme Court justices. This will have tremendous economic benefits, impact for millions of gays and lesbians in the U.S. who now will be entitled to federal recognition of their marriages and also federal benefits like medical insurance and also retirement benefits. The other significant ruling, also in a 5-4 decision, that the Proposition 8 measure, which effectively bans same-sex marriage in California and was recognized by a federal court as being unconstitutional, well, that ruling in California will stand. The Supreme Court saying it does not have jurisdiction on this case and sending it back to California, in effect recognizing the previous ruling and allowing same-sex marriage to continue in the state of California. Tremendous reaction as a result of these rulings coming out of the Supreme Court. Many, though, disappointed with the rulings that were coming out. Many Christians in the U.S. saying that, in fact, this was a very dark day in U.S. history. The U.S. Conference of Catholic Bishops less than pleased, calling this a tragic day for marriage and for our nation. However, many gay rights activists who are here at the U.S. Supreme Court as this ruling was coming down were more than pleased. In fact, the atmosphere was one that was jubilant and celebratory. They say this is a turning point, a tremendous day for civil rights in the United States.
But just 24 hours earlier, it was a very different atmosphere when the Supreme Court struck down key parts of the Voting Rights Act, one of the key accomplishments of the civil rights movement. The law made it mandatory for states with a history of racism to get approval from the Department of Justice before changing any electoral laws. On Tuesday, the Supreme Court judged that the formula to determine which states needed extra scrutiny is outdated. So, what do these decisions mean for equality in the United States? And joining me is Spencer Overton. He's a law professor at George Washington University and author of the book Stealing Democracy: The New Politics of Voter Suppression. Also with us, Bruce Fien, a constitutional lawyer and the former U.S. Associate Deputy Attorney General under President Ronald Reagan. And from Denver, Colorado, Paul Campos, law professor at the University of Colorado Boulder. Professor Campos, first of all, on the Defense of Marriage Act, as far as the majority opinion is concerned, is this now a clear victory for equality?
Well, it's a little bit more ambiguous than that because the majority opinion actually didn't hold that there was a fundamental right to same-sex marriage, nor did it hold that gays and lesbians are due higher protection than because of their sexual orientation. In other words, they didn't say that there was supposed to be strict scrutiny of laws burdening them. Nor did the opinion actually state any very coherent rationale for why it was overturning the Defense of Marriage Act. So while it's definitely a victory, I think, for gay rights in this country, there's no question about that, it's not nearly as far-reaching or groundbreaking a kind of decision as it's being characterized immediately in its wake, in my view.
So, but are you suggesting that there might be further problems down the road, the need for further legislation, perhaps further litigation, Professor Campos?
Yes, I think there certainly will be quite a bit of further litigation because right now we have a very unsettled situation. We have a situation in which the federal government is prohibited from not recognizing same-sex marriages that are recognized by states that recognize such marriages. It's unclear to the extent to which other states are going to have to recognize same-sex marriages from jurisdictions that do recognize same-sex marriages, given that the large majority of U.S. jurisdictions still don't recognize same-sex marriage. So it's frankly a rather confused legal situation at the moment, and I think it's going to take quite a while, probably quite a few years, for this to play out more fully on the legal stage.
All right, let's move on to the other major bit of civil rights legislation then this week at the Supreme Court, the Voting Rights Act. Basically, the ruling was not that it was unconstitutional for the federal government to oversee states with a history of racism to ensure they're not being prevented from voting, but that the criteria being used to judge whether that is happening is outdated. Is that correct, Professor Campos?
Yeah, that is correct. And this is very, very significant because it really deals a very serious blow to the most powerful enforcement mechanism within the Voting Rights Act, which are these pre-clearance provisions that require states and other jurisdictions that have a history of racial discrimination in regard to voting to get any changes in their election laws cleared through the Department of Justice before they can become legally effective. And the court threw that out and essentially said Congress has to, if they want to, have to try to draft some other kind of test or mechanism for this kind of a procedure, because this one has become unconstitutional. And I think this is a very serious blow to the Voting Rights Act, and in fact an extremely poorly reasoned opinion that, in my view, really doesn't stand up to any kind of critical scrutiny.
All right, well, let's have a little bit of that majority opinion off Chief Justice John Roberts. He actually, in fact, argued that due to the effectiveness, in part, of the Voting Rights Act, it needed to be amended to reflect modern racial views. Quote, during that time, largely because of the Voting Rights Act, voting tests were abolished, disparities in voter registration and turnout due to race were erased, and African Americans attained political office in record numbers. And yet the coverage formula that Congress reauthorized in 2006 ignores these developments, keeping the focus on decades-old data relevant to decades-old problems, rather than current data reflecting current needs. Professor Overton, the argument seemed to be, yes, it's working, but there's this concept of supposed deterrence. If you decide that the only reason it's working is because of the law, then it's never going to be overturned, and states can never prove that they really have changed, you see.
Well, actually, under the old system, a state could bail out if it had a clean record for 10 years. And in fact, a quarter of the counties in the state of Virginia had bailed out. I think something else that the Chief Justice ignores is the fact that we're not just talking about turnout or registration of minorities, we're talking about politicians manipulating rules like redistricting rules to diminish the influence of a particular population. So I think it's a little more complex than the Chief presents.
Bruce Fien, you agree, though, that the criteria are outdated. Those criteria in Section 4 of the VRA, which then influence or then inform Section 5 on
well, the coverage of the pre-clearance requirements.
Right. But, those criteria, though, are the levels of voter registration, turnout rates in elections, whether devices like literacy tests are being used.
Had been used in 1964, years ago, because Congress has outlawed all literacy tests nationwide, and the Supreme Court has upheld that, so no state or locality can use a literacy test. And another element that I think has gone unobserved is Section 2 of the Voting Rights Act, which was implanted there in 1982, which was the strictest standard yet enacted, that says any voting method that results in discrimination is invalid.
Actually, and correct me if I'm wrong, Justice Roberts actually didn't, I mean, he agreed with that, though, didn't he? Didn't
that's undisturbed. Section 2 is not affected at all. And that's a very strong test, far beyond just the 15th Amendment intentional discrimination test. And one of the things I think...
Just to explain that, the 15th Amendment says no one... that the right to vote should not be abridged on the basis of race.
The intentional discrimination. And one of the things that I want to call attention to is a case called Shaw versus Reno. Many years ago, the Supreme Court held that intentional racial gerrymandering, drawing district lines for the purpose of electing either a black or white official, was unconstitutional. After that decision, it was said by many, all the incumbent blacks will be threatened with losses because these racially gerrymandered districts were essential to black representation. It proved untrue.
Professor,
all of them were reelected.
You're dying to get them.
Yes, the 15th Amendment also says that Congress shall have the power to enforce this through appropriate legislation. So in other words, this is really a decision for Congress to make about which states should be covered. And Congress thought about this issue in 2006, right? They had 91 witnesses, they had 21 hearings, they had 15,000 pages of a legislative record, and they decided to cover the states that are covered.
And we have a map, actually, of the states that were covered. Most are in the South, including Alabama, Arizona, Georgia, Louisiana, and Mississippi. Bruce Fien, are you suggesting, though, that there are no attempts anymore to disenfranchise minorities, that racism has been eradicated, that it's a coincidence that in some of these states there is legislation underway, or actually now being enacted as we speak as a result of the Supreme Court legislation to redraw district lines, to have
well, we know that if they're redrawn for racially discriminatory purpose, they're illegal and unconstitutional under Shaw versus Reno. And remember, the pre-clearance standard says that before a law takes effect, that you have to have clearance from the Justice Department or a court here saying it has no discriminatory purpose or effect. It doesn't mean that even if it clears, you can't attack the law later on. That's how customarily things operate. And think about this. In the last months, we've had numerous state legislatures enact laws saying you can't have an abortion after 20 weeks or 12 weeks or 14. It looks like an assault on Roe v. Wade. But the Justice Department doesn't review the laws in advance. They're attacked afterwards.
Professor Overton, very quickly, but I have to bring Paul Campos back in there.
Litigation costs millions. Litigation is often too expensive for voters to bring. It takes years. It's not as efficient as pre-clearance. Pre-clearance was efficient in stopping discrimination before it started.
Professor Campos, a great deal has been said on multiple levels, really. Perhaps you just want to respond to whichever feels the most relevant to you.
Sure. I really want to emphasize what I think is a critical point that Spencer made. Which is that when we ask the question about whether this is the right scheme to enforce the 15th Amendment, the Supreme Court's own doctrine says that as long as there's any rational basis for Congress to decide to do something in this sort of way, then the Supreme Court should have nothing to do with it. And the 15th Amendment explicitly gives the power to pass this kind of law to Congress. And so what Chief Justice Roberts was supposedly burdened with doing was demonstrating what constitutional provision would lead to the extraordinary conclusion that Congress didn't have a rational basis for drawing up the tests in this kind of way and maintaining them. And so what we really have here, I think, is that bugbear of conservatives, judicial activism in its sort of most florid and unjustifiable form. The Supreme Court basically is saying Congress has a method here for rooting out racial discrimination in the case of voting rights, but we think that they could come up with a better one, and we're going to force them to do so, even though under its own doctrine, the Supreme Court says it's not supposed to do that, since the Constitution explicitly gives this power to Congress.
Right. And I think we'll return to the division of labor between the Supreme Court and Congress later in the show, hopefully. But there are two things we just want to get in here. First of all, though, a poll that was conducted last month showed Americans are also split evenly on the necessity of the Voting Rights Act, though. 49% believe the law is still necessary. 44% say it's no longer needed. But the results are split along racial and party lines. Blacks and Democrats more likely to say the act is needed, while whites and Republicans were more likely to say it's not. Professor Overton, though, I mean, this is by no means a matter of obvious consensus amongst the American people as well, though.
Yeah, Shihab, I think we have to look at something, how U.S. law is different than around the world, right? In the United States, elections are administered on the state and local level, right? And often by politicians, not by civil servants. So you have elected politicians who want rules that benefit themselves. So sometimes if there is a rule that excludes a particular ethnic group, but that helps a politician, that politician might support that law. And this federal law, preclearance, prevented that. It was a check on that. There was deterrence here. So what we're going to see is more manipulation by especially state and local politicians of these rules, especially where we have growing populations of like Latinos, Asian Americans, others threatening the status quo.
Let me just explain that term preclearance, which is going to come up quite a bit. So in Section 4, it gave the criteria then for when a state needed extra oversight, but
the coverage formula,
and that oversight is called preclearance. Basically, they have to pre-clear legislation.
Right. Section 5 is preclearance.
But what's being neglected? Congress is made of politicians too. They have ulterior political motives to try to keep a system, including preclearance, in effect, that they think helps them. It's not just local politicians who are driven by political considerations. Members of Congress do that every day.
But there was another key question. During the oral arguments in February, the Obama administration had no answer to what Justice Roberts himself said was the key question. Quote, is it the government's submission that the citizens of the South are more racist than the citizens of the North? And the Obama administration lawyers didn't have an answer for that. In fact, they said no, I think. However, subsequently, two law professors, Christopher Elmendorf and Douglas Spencer, sought to find out if that question could be answered, and so help in the drafting of future voting rights criteria. And earlier I spoke to Professor Spencer, one of the authors of that report. He explained that study's methodology and what should be next.
Well, we're taking advantage of the fact that in 2008, a group of political scientists and the Annenberg Public Policy Center administered two large-scale surveys. Each survey had about 20,000 respondents, nationally representative across the United States. And they asked a whole host of questions about political attitudes, but because in 2008 there was a black candidate running for president in Barack Obama, they asked several questions about race. So, for example, they would ask respondents to rate their own race on a scale from 0 to 100, how lazy, how untrustworthy, how unintelligent you think your own race is, and then it asked all respondents to answer the same question about blacks. And so we were able to take the difference in each respondent's answers to these questions, and then we aggregated those differences by state, and that gave us a ranking of states where there's a large population of people that harbor these negative stereotypes about black people relative to other states.
Right, but using that data, how can you come to a conclusion that someone is definitively racist?
Well, we're certainly not claiming that people are racist per se, but that they hold negative stereotypes about blacks. And the difference, one of the limitations for sure of using survey data is what is called social desirability bias. And that is, we can't be sure that somebody's answering a survey question honestly. However, these surveys were administered online and in private. There was no researcher sitting across asking these questions. So we believe that the privacy of answering questions on an internet survey provided a forum for people to be honest. Now, certainly another interpretation of our findings is that certain states harbor populations that are more willing to express negative stereotypes about black people, even if it's not true that deep down they actually harbor those stereotypes. But we think there's probably a good deal of both, and given the nature of the survey, we think that our findings are pretty robust.
So in which states then did you find there was a significant amount of racial prejudice present?
Well, as it turns out, in a lot of the states that were covered under the Voting Rights Act, using the formula that was invalidated yesterday, Louisiana, Mississippi, Alabama, Georgia, Texas, South Carolina, 6 of the 9 states with the most prejudiced people were covered under the formula that was invalidated yesterday. The other states that are in the top 9 include Arkansas, which was a state that was, quote, bailed in under Section 3 of the Voting Rights Act. And we think that it reflects the fact that the coverage formula, though it was based on election practices in the 60s and 70s, actually was doing a good job reflecting current conditions in the state of people's racial attitudes today.
But that may be, but what about the argument, though, that given the levels of registration and turnout amongst African Americans in some of these states, which was the basis of the formula for whether a state needed federal oversight, that there is no need for that federal oversight because African Americans in the state themselves can now use their democratic power in order to fight racial prejudice?
It's a really great question at the crux of the decision, for sure. It's interesting that Chief Justice Roberts uses all of these statistics about registration and turnout to prove that the Voting Rights Act has done its job, but in the same breath says that registration and turnout statistics are irrelevant for determining whether the Voting Rights Act is constitutional. So the point being, the cases that were being brought in the 60s were based on ballot access, were black people in particular able to get to the polling station and cast their ballots. Now we're facing second generation barriers about at-large elections, redistricting, etc. These are questions that are not necessarily based on turnout or registration, but about structural issues and about the attitudes of the electorate that's participating in the process.
Bruce Fien, I mean, that leads to that question, though. And by the way, that was Douglas Spencer talking to me a bit earlier. Should a state with demonstrably racist inclinations and institutions have total sovereignty? Even Justice Roberts didn't argue for that, but you seem to be heading in that direction there.
Listen, what I think I would part company with Paul, the Supreme Court has said the legislative power of Congress in implementing the 14th and 15th Amendment needs to be proportional to the wrongdoing, and the remedy's got to be congruent with what's found faulty. To say a state has a history of racism, well, the degrees could be enormously different. You could go back to the days of Bull Connor and James Clark, and you got the water hoses and the cattle prods, as opposed to changing from a district to a general multi-member district. And those are hugely different. Obviously, there is a risk anytime you permit any state to enact any law without preclearance, because there can be a whole host of violations of constitutional rights that occur. It could be Fourth Amendment, it could be the right to privacy under Roe v. Wade, and it could be racial discrimination.
Right,
and
but even Justice Roberts said that Section 2 of the VRA should stay in place.
That is correct, but Section 2 is not preclearance. Section 2 enables someone...
But it's oversight, though. It is the need for vigilance.
Right, and I'm not saying that there isn't a need for judicial oversight. I'm not saying the judiciary gets to shut its eyes to a litigant claiming here's racism. Section 2 is exactly what Congress has done consistently with the 15th Amendment to give citizens who believe a law is discriminatory an opportunity in court to prove it.
Professor Campos, you raised this a bit earlier, though, is what is that division then between the Supreme Court and Congress? And what's interesting and perplexing, perhaps, is in Justice Scalia's dissenting opinion to the gutting of DOMA, the Defense of Marriage Act, he said the following, quote, "That is jaw-dropping. It's an assertion of judicial supremacy over the people's representatives in Congress and the executive. It envisions a Supreme Court standing, or rather enthroned, at the apex of government, empowered to decide all constitutional questions, always and everywhere, primary in its role." So that's Scalia railing against reversing DOMA, which says that marriage is only between a man and a woman, and yet he seemed quite happy to do that the day before on the Voting Rights Act. Can you help us understand that?
Well, I think the way to understand that might be through the sociology of knowledge, and I'll quote the great scholar David Reisman on that point, who said that ideology is what allows a man to believe his own propaganda. And I think that's really what you're seeing in the case of Justice Scalia. I mean, those two, his dissent in the DOMA case and his joining of the majority opinion in the Voting Rights Act case, I don't think can be squared at all, because they are diametrically opposed on this fundamental point of process and jurisdiction, which is that, according to him, in the context of DOMA, the Supreme Court should only step in instances where they clearly have a mandate to do so through the Constitution. But in the case of the Voting Rights Act, the Constitution actually gives this mandate very explicitly to Congress, and the Supreme Court, through 50 years of precedent, had held up until a couple of years ago that it was very much the role of Congress to decide how to enforce the 15th Amendment in the context of the Voting Rights Act, as indeed Section 2 of the 15th Amendment explicitly says.
Very briefly then, Professor Overton, this has been, even by the Supreme Court, then turned back to Congress. They say, okay, come up with some criteria that we can live with, and then that's okay. Right. But are they going to do this anytime soon?
Well, Congress certainly should. They should update the Act. You remember in 2006, 98-0 was the vote in the Senate to renew the Act, so certainly they should update it. Here's what they should do. One, they should update preclearance, so places with recent voting rights violations and also new voting rights violations going forward, so that they are covered. Streamline litigation, make it less expensive, make it faster. The third thing they need to do is disclosure of election law changes and their effects to deter bad activity.
Right, but are they going to do it? And President Obama, he's not a man to take leadership in issues of race, as we've discovered. Even his reaction yesterday, I'm deeply disappointed. Didn't seem,
Well, you say leadership in terms of issues of race. Hate crimes passed. DREAM Act, he's a big supporter of. Pell Grants, crack crack cocaine disparity. There have been a lot of accomplishments along
So he's
racial
gonna use
lines
the bully
with
pulpit
regard
now.
to.
But
yes.
Congress, in my judgment, will do nothing. If all the horrors happen, then there might be a momentum out to do something. But until we find actual bodies in the street, Congress will not move.
Bruce Fien, thank you very much. Professor Spencer Overton, thank you. Professor Paul Campos, thank you as well.
Shihab, thanks so much.
And that's all from the team in Washington, D.C. for now.